The bailiff called her name wrong. He looked down at the docket, squinted and said, Kessler? And when she stood up, all 5'4" of her in a charcoal blazer she'd pressed 3 times that morning, he looked right past her toward the back of the courtroom, as if whoever he was actually looking for must be taller, older, whiter, or some combination of the three. "That's me," said Danielle Kessler-Obi. "I'm counsel for the defense." The bailiff blinked. Then he looked at the senior partner beside her, a large man named Gerald Whitmore, who had not said a single word, and was only there to observe, and seemed to decide that this made more sense. "Right," the bailiff said. Of course, she had been a lawyer for 4 years. She had graduated second in her class at Osgood Hall. She had passed the bar on her first attempt and had spent every day since working 14-hour shifts in a downtown Toronto firm that prided itself on taking impossible cases and winning them. And still, every single time she walked into a courtroom, somebody looked past her. She took her seat, opened her file, and did not say anything. She had learned, a long time ago, that the time to talk was not now. The case was called Brennan v. the Province of Ontario, and most people in the legal community had already decided it was over. Vincent Brennan was 61 years old. He had worked for the provincial corrections system for 27 years before being let go, in what his former employer described as a routine restructuring. The termination notice arrived 6 weeks after he filed an internal complaint, alleging that the warden of his facility had been falsifying inmate transfer records, a practice, he claimed, that had been going on for at least a decade and that had resulted in at least 3 inmates serving longer sentences than their court orders specified. The province said the timing was a coincidence. Vincent said it wasn't. He filed a wrongful dismissal suit combined with a whistleblower protection claim, and 3 different law firms had turned the case away before he walked into Danielle's office on a Thursday afternoon in November, carrying a grocery bag full of photocopied documents. Her supervising partner, Howard Tremblay, had looked at the file for 45 minutes and then handed it back. "There's no paper trail connecting the termination to the complaint," Howard had said. "Everything they did is technically within policy. You'll never get past summary judgment." "I don't think that's true," Danielle said. Howard smiled the way people smile at children who insist that the moon is made of cheese. "Danielle, you've been practicing for 4 years. This case has already beaten lawyers with 25. Let it go." She didn't let it go. She spent 11 months building the case from a grocery bag of photocopies into something that could stand up in a courtroom. She tracked down 3 former employees who had left the facility under similar circumstances. She filed access to information requests that came back mostly redacted, then filed again with more specific language. She pulled every inmate transfer record the province had submitted in the past decade and cross-referenced them with the originating court orders, one by one, in a spreadsheet she kept open on her laptop every night after her roommate went to bed. What she found took her breath away. 41 cases, 41 inmates whose transfer records had been altered. In most cases, the change was small. A date shifted by a few months, a facility designation quietly updated. But in several cases, the changes had extended actual time served by more than a year. One man, a 34-year-old named Curtis Ibarra, who had been convicted of a nonviolent drug offense, had served 22 months beyond his original sentence because a transfer that should have moved him to a minimum security facility for early release review had been delayed, rescheduled, and eventually lost in a bureaucratic shuffle that Danielle did not believe for a single second was accidental. She filed the expanded claim on a Monday morning. Howard Tremblay called her into his office by noon. "You added a systemic rights violation," he said. "That's a charter argument. You're going to trial against the provincial government on a charter argument." "Yes," Danielle said. "Do you understand what that means in terms of resources? They will assign 20 lawyers to this. They will drown you in paper. They will file every motion available to them, and some that aren't yet." "I know," she said. This is not a winnable case, Danielle. I've heard that before, she said. About this exact case, by lawyers who hadn't looked at the transfer records. Howard was quiet for a moment. He was a fair man, even when he was being condescending. He looked at the chart she'd placed on his desk. 41 names. 41 case numbers. 41 discrepancies. Who else knows about this, he asked. No one outside this office. He looked at the chart a little longer. I'll assign Gerald to observe. For oversight. I don't need oversight, she said. Everyone needs oversight, Howard said. And Gerald won't get in your way. Gerald Whitmore, in the 4 months since that conversation, had said approximately 47 words to her, almost all of them variations of carry on. He sat beside her in the courtroom now like a very expensive coat rack, and Danielle was grateful for him in the way you are grateful for furniture that holds its shape. The presiding judge was the Honorable Justice Reginald Forsyth. He had been on the bench for 19 years and was known for 3 things: a sharp memory for procedural rules, an exceptionally low tolerance for wasted time, and a manner of looking at holes that suggested he had better things to do than listen to them. He had not been unfair to her in the proceedings so far. He had also not been warm. He looked at her the way a man looks at a door he isn't sure is load-bearing. The province's lead counsel was Marcus Gleason, a QC, with 30 years of litigation experience and a reputation that preceded him by about 3 hallways. He was a tall man with silver hair and the particular kind of confidence that comes, not from arrogance, but from having been right so many times in a row, that he no longer considered the alternative. He had nodded at Danielle on the first day of trial. She had nodded back. They had not spoken since. On the morning of the 4th day, Gleason stood up and made a motion to strike her expert witness. The witness was Dr. Amara Singh, a professor of administrative law at Queen's University, who had spent 15 years studying institutional record-keeping practices in Canadian corrections. Dr. Singh had been prepared to testify that the pattern of alterations Danielle had identified was statistically inconsistent with random error, that the changes were systematic, directional, and in her professional opinion, intentional. Gleason argued that Dr. Singh's methodology was not sufficiently peer-reviewed, that her conclusions exceeded her area of expertise, and that admitting her evidence would prejudice the province's ability to mount a fair defense. Justice Forsyth considered the motion for a moment and then looked at Danielle. Response. This was the part Howard had warned her about. The province had filed the motion at 8:30 that morning. She had received it at 8:42. She had had 17 minutes to prepare. She stood up. "Thank you, Your Honor," she said, and her voice was completely steady. She had been practicing that steadiness since she was 9 years old, and kids at her school in Scarborough had laughed at the way she pronounced her mother's surname. You keep your voice steady and you say the thing you need to say. Dr. Singh's methodology is not novel. It is the same statistical framework used in the 2019 Ontario Auditor Review of Provincial Healthcare Record-Keeping. A review that was not only peer-reviewed but was cited approvingly by the Supreme Court in R.V. Mountford. If the province wishes to challenge its admissibility, they are simultaneously challenging a methodology endorsed by this country's highest court, and I would respectfully suggest they may want to reconsider the strength of that position. Justice Forsyth looked at Gleason. Gleason, to his credit, did not waver. The analogy to Mountford is imprecise, Your Honor. The healthcare context is materially different from. Pull up Mountford for me, Justice Forsyth said. To nobody. In particular. His clerk scrambled. Danielle had Mountford open on the second tab of her laptop. She had put it there at 8:47. The citation took 4 minutes to locate. Justice Forsyth read a passage. He looked at Gleason. He looked at Danielle. He looked at the ceiling in the way that very senior judges look at ceilings when they are making up their minds about something that was actually made up before they looked at the ceiling. Motion denied, he said. Dr. Singh's evidence will be admitted. We'll take a 15-minute recess. Gleason sat down. He did not look at Danielle, but the junior counsel beside him, a young woman who could not have been more than 2 years out of law school, did. She looked at Danielle with an expression that Danielle recognized immediately, because she had worn it herself. The look of someone watching something happen that they had been told could not happen. Danielle gathered her papers. Gerald Whitmore leaned over and said, very quietly, "Nice." That was word 48. The recess lasted 12 minutes. When they reconvened, Danielle called her first witness of the day. A former records administrator from the Harrington Correctional Center named Beverly O.C. McCauley, who had left the facility in 2017 under what her separation agreement described as a mutual decision. Beverly was 63 years old and had driven down from Peterborough that morning in a 2009 Honda Civic. She had called Danielle 3 times the night before to make sure she still wanted her to come. "I kept thinking," Beverly had said on the third call, "that someone was going to tell me it wasn't worth it, that they'd settle before trial and none of this would matter." "It matters," Danielle had said. "Come." Beverly sat in the witness box in a blue blazer and answered every question Danielle asked her with the quiet precision of someone who had spent 24 years filing documents and knew exactly what those documents were supposed to say. She described the system. She described what happened when records didn't match. She described the conversation she'd had with her supervisor. In March 2016, when she flagged 3 transfer discrepancies and was told to note them as administrative corrections and move on. She described the meeting with HR 6 months later. She described the exit package. She did not cry. She came close once when Danielle asked her to read the name at the top of one of the transfer documents, one of the 41. But she steadied herself and read it clearly, and the courtroom was very quiet. Gleason's cross-examination was precise and methodical. He established that Beverly had not personally witnessed any deliberate falsification. He established that administrative correction was a term used throughout the provincial system for a range of legitimate record updates. He established that she had signed a separation agreement with a non-disparagement clause. Though the agreement itself had been produced in discovery and the clause did not bar truthful testimony. It was a professional cross-examination. It did not undo what Beverly had said. When she stepped down, Beverly walked out of the courtroom without looking at anyone except Danielle. And the look she gave her was not relief or triumph. It was the specific exhausted gratitude of someone who has been carrying something for a very long time and has finally been allowed to set it down. The afternoon session was harder. Gleason called a deputy warden from the Provincial Corrections Administration to testify about standard record-keeping protocols. The deputy warden had been very well prepared. He answered every question with confident specificity, cited internal policy documents by number, and managed to make the entire enterprise of provincial record-keeping sound not only competent, but almost noble. He smiled warmly at the jury. There was no jury. This was a judge-alone trial, but he smiled at approximately where a jury would have been, because this was the kind of witness who had given evidence many times before. Danielle waited. Her cross-examination began at 3:42 in the afternoon. She had 45 minutes before the day ended. She spent the first 15 on the policy documents, confirming them, clarifying their scope, establishing their application. The deputy warden settled in. He was comfortable. He had been asked about policy documents before. Then she said, "I'd like to draw your attention to Policy Directive 742, which you cited in your direct examination as governing the process for administrative corrections to inmate transfer records." "Yes," he said. "Can you tell me when that policy came into effect?" "It was." He glanced at his notes. "It was implemented in 2014, and prior to 2014, what policy governed that process?" A small pause. "There would have been an earlier version." "There was," Danielle said. "Directive 68.1, which was in effect from 2006 to 2014. I'm producing a copy as Exhibit 47. She handed the document to the registrar. Can you confirm that under 6.8.1, any administrative correction to a transfer record required a supervisor's countersignature? Yes. I believe that's correct. And can you tell me whether, in the records produced in this proceeding covering the period 2009 to 2014, the 41 documents we've identified as containing corrections were countersigned by a supervisor? He looked at the exhibit. He looked at his notes. He looked at Gleason, which was a thing you are not supposed to do. And Gleason had the presence of mind to look at his own papers. I would need to review the specific documents, the deputy warden said. I've prepared a summary, Danielle said. I'm producing it as Exhibit 48. She handed it to the registrar and sent a copy to the screen above the witness box. 41 rows, 41 entries in the counter-signature column, every single one blank. Is it fair to say, Danielle said, that under the policy that was in effect at the time, not one of the 41 corrections we've identified was properly authorized? The courtroom was very quiet. I would need to review. The deputy warden began. The documents are before you, Danielle said. Not unkindly, just precisely. Justice Forsyth leaned forward. Witness, please answer the question that was asked. The deputy warden looked at Exhibit 48 for a long time. Based on this summary, he said finally, it appears that counter-signatures are absent. Thank you, Danielle said. No further questions. She sat down. Gerald Whitmore did not say anything. He did not need to. Across the room, she could see Marcus Gleason writing something on a yellow legal pad, and she did not need to be able to read his handwriting to know what it said. That night, she sat in her apartment in Leslieville and ate cold pad thai from the container and did not think about the case. She thought about Beverly O.C. Macaulay driving home to Peterborough in the 2009 Civic. She thought about Curtis Ibarra, who had served 22 months longer than he should have, and who had been 34 years old when it happened, and was now 38, and who she had spoken to twice, and who had not, in either conversation, asked for anything except to be told what was happening. She thought about her mother, who was a nurse, and who worked the overnight shift at Sunnybrook 3 nights a week, and had, when Danielle told her she was taking this case, said, "Good, take it. Somebody has to." She washed the fork. She went to bed. Closing arguments were on a Thursday. Gleason went first. He was very good. He was measured and thorough, and he acknowledged the counter-signature issue without minimizing it. Described it instead as a failure of administrative process. That was real and serious, and that the province did not dispute. But that was categorically different from the intentional, systemic, coordinated fraud that the plaintiff was alleging. He used the word inferential 7 times. He said the evidence required the court to make leaps that the law does not permit. He spoke for 51 minutes and he was, in every technical sense, excellent. Then Danielle stood up. She did not have notes in front of her. She had had the closing argument in her head for 6 months. "Your Honor," she said, "the province has asked you to believe that 41 records were incorrectly modified. None of them authorized under the policy that was in effect at the time. All of them coincidentally in the same direction, extending custody rather than reducing it, spread across a decade of operations at a single facility, and that this pattern is the result of administrative error rather than administrative decision." She paused. With respect, a pattern is not an accident. A pattern is what remains when you remove coincidence, and what we have here is not coincidence. What we have is 41 people. 41 people who went to sleep at night not knowing that the date on which they would be permitted to return to their lives had been quietly altered by someone who did not believe the rules applied to them. She talked about Beverly O.C. Macaulay. She talked about what Beverly had described when she flagged the discrepancies in 2016, and was told to note them as administrative corrections and move on. She talked about what that instruction meant in context, not in isolation, not as a bureaucratic shortcut, but as the specific instruction that allowed an already existing pattern to continue for another 2 years. She talked about Vincent Brennan, who had worked in the system for 27 years and had noticed the pattern and had written it down and filed it internally, and then, 6 weeks later, received a notice that his position had been eliminated. She talked about the law. She was precise and careful, and she did not overstate. And then, she said, "The charter protection against arbitrary detention exists because the founders of this legal system understood that the power to hold a person against their will is among the most serious powers a government can exercise. It must be exercised according to clear rules. It must be subject to oversight. And when it is violated, when the records that govern a person's liberty are altered without authorization, without supervision, without accountability, the law must say clearly what that violation is." She paused again. "We are asking this court to say it clearly." She sat down. The room was quiet for a moment, the particular quiet of a room where people are still thinking about what they just heard. Then Justice Forsyth said that he would reserve his decision. She walked out into the October air on University Avenue and called her mother. "How did it go?" her mother asked. "I don't know," Danielle said. "Probably fine, Danielle. Probably good," she said. "I think it went well." "Good," her mother said. "Come for dinner Sunday. I'm making soup." The decision came on a Friday 14 days later at 2:15 in the afternoon via email. Danielle was in a meeting about a different case entirely when her phone lit up with Howard Tremblay's number. She excused herself. "Have you seen it?" Howard said. "I'm seeing it now," she said, and walked to a corner of the hallway and opened the PDF on her phone and read. Justice Forsyth had found for the plaintiff on all grounds. He had accepted Dr. Singh's methodology. He had accepted Beverly O.C. McCauley's testimony. He had found that the absence of countersignatures on 41 records combined with the systemic directional nature of the alterations established on a balance of probabilities that the modifications were intentional. He had found that Vincent Brennan's termination was causally connected to his internal complaint. He had found a breach of Charter Section 9 with respect to the affected inmates and had ordered the province to conduct an independent review of all transfer records from the Harrington facility going back 20 years. He had also, in a passage near the end that she had to read twice, noted that the level of preparation and evidentiary organization demonstrated by the plaintiff's counsel had considerably assisted the court in navigating a factually complex record and was worthy of specific acknowledgement. She stood in the hallway and breathed for a moment. Howard was still on the line. "Well," he said. "Well," she said. "I may have underestimated this one," he said. "You may have," she said. She was not unkind about it. There was no point in being unkind about it. She called Vincent Brennan next. He answered on the first ring, which meant he had also been watching his phone. She told him the result and he didn't say anything for a moment, and then he said, "The review, the 20-year review, that was your idea?" "It was in the claim," she said. "I didn't expect them to grant it." "I did," she said. He laughed a little, a short, winded sound, like someone who has been holding their breath and is remembering how to stop. 27 years, he said. "I kept thinking, even if we won, nobody would look at the rest of it. Nobody would go back." "Somebody will now," she said. She called Curtis Ibarra last. He didn't pick up. She left a voicemail. She said that the decision had come down and that it had gone their way and that the independent review might eventually result in additional proceedings that could affect his case, and that she would be in touch, and that she was sorry for the time he lost, and that she was glad they could do something about the time remaining. She meant all of it. Danielle Kessler-Obi almost always meant what she said. The following Monday she arrived at the office at 8 and found a card on her desk. It was from the other junior associates, 6 of them, all around her age, all of them people who had watched the past 11 months happen from the other side of glass office walls. The card said, simply, "We saw." She put it in her desk drawer and got to work. That evening, Beverly O.C. McCauley sent a text message. Just 3 words. "Thank you, Counsel." Danielle looked at it for a while. The way you look at a thing that is small and heavy at the same time. A thing that weighs more than it should because of everything that had to happen before it could be said. She typed back, "Thank you for coming." And that, as it turned out, was exactly enough.